Hello.
Hello.
All right, so on this case, where are we, counsel, with discovery and with offer?
Your Honor, there is an offer. I just want to let the court know this case is a couple years old. I was just appointed on August 5th while I was on vacation.
Okay,
So I've only been on it about a little over 2 weeks. My first notice of a hearing was just a week ago. But I did notice, it appears all discovery is there, except I did notice that this search in this case happened at the magistrate's office. I know they have cameras there. I don't know if they still have it. I talked to the state and I think she's willing to check to see if those records still exist. That's all I need. Now, I will say, Judge, my client is in a hurry to go to trial, and I think I can be ready very quickly on this, maybe as early as next week. But I was hoping, or whenever the court is ready also.
well, no, what I can tell you next week is out of the question. The reason why it's out of the question is because there's a judicial educational conference everyone must attend. You know, judges must keep up with their education as well. So I don't have a judge that's available for
Okay, that's
that week.
Can we wait, Judge? Then it can. I was wondering. My second question was be whether we could come back Friday. I'd like to have his custodial status addressed. I'd like to file a motion. He was out of custody for 2 years, no problems. Had an issue with the court date. He's now been in custody for about 51 days. And I wanted to see if I could address that on Friday.
Not on Friday, but I can recall you for tomorrow.
Oh, that's perfect. Do I need to file a motion, Judge, on that?
You'll need to speak with the state if they want to proceed without your filing of a motion.
Judge, if they're ready or willing, I could go today.
Yeah, we can just do it today, Judge.
Okay, if the court's okay with that.
No.
No, okay, tomorrow's fine too. Yes,
Tomorrow.
okay, no problem, Judge. Okay.
All right. And the reason why is because there's information that I would need. And sometimes when you're doing things on the fly, people don't have that information. And then we've been here for 40 minutes and the information isn't with me. Okay. So we'll bring you back tomorrow. Okay.
Yes, ma'am.
All right. Thank you.
Judge, and you did ask me to bring back pictures of my vacation, which I have here that you can slide through if you'd like.
Oh my gosh. It's so beautiful.
Yeah.
Oh, Mr. Frank.
And where you're staying is beautiful. Oh
Isn't
my
it
gosh.
amazing? Yeah.
The rainbow.
Isn't it that was amazing.
Talk to you so I can figure out if I can get my mom there.
It's really easy and it's so great because there's no tourists. You have the island all to yourself. It's okay.
All right, who's ready?
I have two, please. The first one I have is already on. Judge.
Hi.
Thank you. I was just admiring the roses. They're so.
Brianna Gonzalez.
Right, Your Honor.
And is there an application?
Yes, Your Honor.
Probation, this is an application. Court is calling 2025 CR 008222 State versus Brianna Gonzalez. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Todd Lessard for Brianna Gonzalez.
And are you Miss Gonzalez?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review the application for deferred adjudication with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with robbery? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
And I'm sorry, counsel, if you can hand me that trial court certification back. I thought y'all had an agreement on the resolution. Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, if you're not a US citizen, you could be deported, not allowed to re-enter into the United States and denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. The state is silent on your applications. There's to be restitution of $2,000 to the complainant. They will take in consideration 2025 CC 003927. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, there's to be no contact with the complainant. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all of its attachments.
No objections.
State you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Counsel, it's for a PSI and a TAP. It's
Yeah.
about 8 to 12 weeks. If you
Right.
want to wait for that, you can. Or if you would like to just present whatever witnesses you want to present and come back in a shorter time, we can do that as well.
I think that would be preferable, Your Honor. She's enrolled in high school and she also has a job waiting for her. And so we're trying to get this behind her as quickly as possible.
All right. So then I'm going to be gone next week. And then the following week, I will be serving jury duty. So I can bring you back that second week, but Judge Angelini will be hearing it, or either I can bring you back to the third week and I will hear it.
Let's do second week's fine, Judge. No offense to you, Angelina.
No,
But
that's
the quicker the better.
all right.
Yeah.
Ms. Ferguson,
Yes, Your
next week.
Honor. Number 8.
And your plea on that was a no contest plea, is that correct?
Yes, Your Honor.
All right, thank you. All right, so we'll bring you back on September 8th.
Is it a PSI or just sentencing?
No, it's just sentencing. They waived PSI and TAP evaluation.
Thank you, Your Honor.
Now, I can tell you with regards to that, maybe Angelini will hear it, maybe he will not hear it since the PSI has been waived, but
Oh,
We
well,
will
if,
see.
you think that's a risk, then maybe.
well, I
we'll-
mean, I don't know. So we'll have it.
Well, if he
brought
does,
back.
if he doesn't hear it, then we can just do it next week. right?
Yes.
Okay.
All right, thank you.
Thank you, Judge. May I be excused?
Yes.
Judge, may I approach when you get a moment?
Just 1 second.
So late, I've been downstairs dealing with something that blew up. Sandra Ramon. The state doesn't have their file.
Have to
Oh, sure.
have them tell me.
I was gonna talk to you about Western Reserve.
I have no idea. They
Oh,
talk a
okay.
lot of.
Sure, sorry.
All right, Sandra Ramon,
That's me.
come forward, please.
She's in custody.
Ah, she's in jail. All right, so that means that she's been sent back. And you are,
We were
For the
court appointed a few weeks ago. What's up?
okay.
Yeah.
No, Discovery, where are you on that?
So they don't even have their file down here, so it's hard for me to say. I've reviewed a
Mhm.
lot of Discovery, but I don't know exactly.
All right, Norma, I need a 30-day reset on Sandra Ramon for Discovery, please.
Okay,
September 25th.
okay. Thank you, Judge.
And you need to speak, because they're putting down people as being hired. I don't know why they're doing
Who's
that.
that? It
In this
was
case, they have you as hired.
definitely,
Uh-huh.
no, definitely. September 24th.
Yes.
Thank you.
All right, who's next? We're getting ready to take our break. Hello, good morning. How are you doing?
Doing all right?
Thank you for dressing appropriately for court.
Yes, ma'am. Thank you.
All right, the court is calling 2025 CR 009749 State versus Cullen O'Neill. Could I have parties announced?
Stephen Spear for the state.
Brian Kimbrough from Mr. O'Neill.
And are you Mr. O'Neill?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. O'Neill, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right. Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. You're charged with online solicitation of a minor sexual conduct. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. O'Neill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, by entering this plea, you can be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $3,000 fine. The state is opposed to your application for community supervision. And there is to be Chapter 62 compliance, and the state is reserving the right to request specific conditions if your community supervision were granted. Did you understand that to be the plea?
Yes, ma'am.
We had, agreed to, with the state, to leave the fine open to the court, the amount.
All right. So any objections to the court? This is what I can tell both parties. No one knows where these fines go when they're collected. Usually unless there's a reason why I shouldn't, normally I probate the fine. So is there any objections to the court probating, writing that as a part of the agreement to probate the fine?
Since that's the court's practice, that's fine with the state.
That's fine, Judge.
All right. But sometimes if the state will present an argument as to why that fine should be in place, I would do it. So I can either just write probated on it, or I can put it below the line.
Below the line is probably better, Judge.
All right, so what I'm gonna do is I'll put it below the line. Is there any objections to the court doing that?
No objection. That's what we kind of anticipated.
Exactly.
Okay.
Thank you, Judge.
Oh, no problem. All right, if y'all would like to initial that. So other than those changes, did everyone understand that to be the plea bargain agreement?
Yes, Your Honor.
And counsel, is that the plea bargain agreement?
It is.
And Mr. O'Neill, do you understand that the only change in your plea bargain agreement is that your attorney wants to argue for not imposing the $3,000 fine, or arguing for something less than the $3,000 fine?
Right.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that there be a $3,000 fine. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
All right, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, at this time, the state would offer state's exhibit number 1 and its attachments.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
It should be a first setting. I have not had time to review the new number 1's discovery, and that's what I'm asking for more time. I believe it's an assault showcase.
Yes. All right, Ms. Ferguson. On this case, set it for a contested hearing, please. And can you put it for the week of September 8th? Would that be enough time for you?
It should be.
Okay.
If not, I'll be back.
I can do, September 9th.
Can I grab my phone?
Sure.
The night should be fine, Judge.
All right, so you're gonna be back on September 9th for a contested hearing. All right, thank you.
Have a seat, sir.
Good morning.
Good morning.
So where are we on discovery on these cases?
On the case that I was initially appointed on in July, late July, I believe I have all the discovery on that case.
Okay. So that is the 2025 CR 005466.
Correct.
And state, in that case, did you tender an offer?
An offer has been tendered, yes, Your Honor.
All right, and then on the case that you've just been placed on, the 2025 CR 010071. State, have you uploaded all discovery?
Zero one zero zero seven one, that's CTE case, I would assume that they have.
Criminal Trial Division. On page 6, Tariano, have you all uploaded all discovery?
Give me 1 second.
All right, thank you. All right, so systems are moving slow.
So sorry.
No problem, it happens. So based upon what I'm looking at on the docket and what that charge is, it should be uploaded.
I have it.
So if for some reason it's not uploaded, come back and let me know.
Mhm.
And what we will do is I'm going to call this for a deadline date in 30 days. And y'all need to confer our docket. I need a 30-day reset for a plea deadline date,
September 25th.
September 25th. So, sir, what will end up happening on that date, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement at that time, your next court date is going to be a jury trial setting. Do you understand?
Yes, ma'am.
Do you have any questions about anything?
No, Your Honor.
All right, thank you.
Thank you.
Your Honor, we had spoken with the CPS attorneys, the 306, and even with their help,
I'm sorry, what?
you had asked us to talk to the CPS attorneys, and even with doing that, we cannot get the CPS worker that's assigned to this case on the phone. He's not responding to any of our attempts.
All right, any objection to the court having the CPS workers Zoom in?
No, I mean, I know that. I mean,
Because I don't have any copies of CPS records.
I know that I spoke with Ashley this morning, and what you were concerned about, she said that the CPS records that she reviewed do look like what you wanted to know. I have no objection with you looking at them. And then they're willing to alter the plea bargain based on what they read in the CPS records. I know you wanted to know what was in them.
Okay, so who has the CPS records? I don't have them.
I would have to print them. I have them on a disk.
All right, if you'll give me the CPS records,
Thank you, Judge.
sure. And any objection to the court seeing if we can get the caseworker zoomed in?
I mean, no, not really. I would I mean, I'm much more comfortable since I've spoken with Ashley about what is contained within them for you to do your in-camera inspection of them, and then we can go forward.
Okay, so part of my job, what I'm supposed to do is I'm supposed to set conditions that will protect the community. And Child Protective Services, their burden of proof is different than the burdens we have over here. So this is a case that's abandonment and endangerment to child criminal negligence. So according to the police report, drugs were being grown in the child's room next to the crib. So I have concerns. Yes. So I'm trying to figure out what's going on so that I don't send a child or have people around a child that's gonna propose a danger. So. Yes. So what ends up happening? Usually people say, oh no, we want the same attorney, but that can result in conflicts. For example, sometimes with drug cases, if you have two people who are charged and an attorney represents them both, who knows? Maybe one wants to say, I'll accept the drug charges. So you can say all the drugs are mine. Where if you're a defense attorney, you're supposed to be advising that person, who knows, maybe against that or saying, look, this is what you're going to be looking at. So conflicts can occur when you represent two. Yes.
Would it be okay with you if I emailed you the record? You can.
Sure.
Okay.
Which case?
On the.
No, I mean her, but I got you, Rick. Thank you.
So Judge, we've conferred with the state. We have an offer. My client and I are going to go through the discovery. So we want to reset to see whether we want to take the deal or whether we want to take it to trial.
All right, sir, how old are you? 30? 38? Okay. All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date. But the reason why I asked that question is because sometimes you have younger people and sometimes it takes younger people longer to understand the consequences of different decisions they make. So if you were telling me you were 18, I would probably give you a longer chance because sometimes there are other people you want to discuss things with.
September 16th.
All right, so we're going to be back on September 16th. That's your plea deadline date. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next date is going to be a jury trial setting. Do you understand? All right, thank you for dressing appropriately for court. Just have a seat and your attorney will bring the reset form to you.
Let me have you sign this here.
All right, anyone else ready?
Yes, ma'am. Richard Dunphy. 5.
Richard Cantu.
That's my client also, Judge. This is yours.
Hello, Mr. Cantu. How are you doing?
Good morning. Good morning.
Good morning. So you received all discovery?
We're going to go through that, Judge. He's in jail right now. I'm getting an offer from the DA. He wants to go to trial at this point,
Mhm.
but I did get him to say, let's reset it one time for a plea deadline
Okay.
so that he can look at the videos of what actually happened. And then we'll decide at that point.
All right. So it's very important that your attorney have a chance to speak with you and show you all of the evidence. You understand?
Yes.
All right. So what I'm going to do is I'll recall this. Norma, can you put this on the 16th as well? I'm going to recall it for a plea deadline date of September 16th. So if you have not reached an agreement on that date, then your next court date will be a jury trial and I'll get you a trial as quickly as I can.
Thank you.
All right. Do you have any questions about anything? All right. Thank you.
Thank you, Judge. We'll talk soon. Okay.
Anyone else?
That's it, Judge. You guys have a great day.
Your water said?
David, your water?
Oh, thank you.
All right. And Rick, have you sent those?
I
Good morning.
Good morning.
All right, so you now know where this court is, right? So court is at 9 a.m., all right? Make sure you're on time next time. All right, so my understanding is from the court coordinator is that you want a chance to retain attorney. All right. If for some reason you can't afford attorney, one can be appointed to you. So do you want to hire one or you want to see about,
I'll get one.
and how long is that going to take?
I don't know. How much time can you give me? Like,
How much time are you asking for?
maybe like a month?
All right. We're going to recall this in 30 days. On that date, you need to come back with an attorney. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson. I need a date.
It's a 30 days, November 25th.
All right, September 25th. Once you sign the reset form, you excuse and make sure you're on time next time, all right? And thank you for dressing appropriately for court.
Yes, ma'am.
All right, yes. All right, can I see the file on Ross, please? All right, yes. Come down, Mr. Ross. All right, so where are we? Mr. McRae?
Well, Mr. Garrett was kind enough to look into it the best he could. He said the incident happened allegedly, I think first week of June, June 1st. My client wasn't taking any cuts until about the first week of August, so their offices had it about maybe 2.5 weeks. So
Okay.
he said it hasn't been assigned to an intake attorney yet.
Mhm.
He was able to at least get the police report. She went through that. And that's pretty much where we are right now. So
All right, Ms. Abrams? On Mr. Ross? That's gonna be recalled in 30 days. And it will be recalled for a contested hearing. I'm sorry, not 30 days. Norma, set that for 45 days in a contested hearing. By then, everyone should have everything. And if for some reason the discovery is not on that new number one, then I'm sure the state will probably request that it be waived.
okay.
October 9th.
Is October 9th good for you, counsel?
Yes, Judge, thank you.
All right, and can you make sure that you're the attorney on the other case? The
aggro?
aggravated.
Could be, you've been at.
Norma, can you make sure he's on the aggravated robbery, please?
Just have the NTR and Robert, she was going to make sure I'm on both.
Oh, I'm sorry, let me call that back
Yeah,
one second.
he is on the other case here.
All right, you're on the other case as well.
I think I'm just to the back.
All right, thank you.
Good.
You're welcome. So this is what a motion. All right, hello. Did you all get a chance to review the CPS records?
The documents that you referred us to, yes, Judge, which looks like the final conclusion.
All right, the court is calling 2025 CR 009798 State versus Jacob Edward Aguirre. Can I have parties announced?
Rick Pena for the state of Texas.
Suzanne Kramer for Mr. Aguirre.
And are you Mr. Aguirre?
Yes, ma'am.
All right, so this was recalled back for sentencing because the court wanted the CPS worker here. And the state informed the court that they were unable to have the CPS worker here. So both parties had no objection to the court reviewing the CPS records. Is that correct, state and defense?
Yes, that's correct.
Yes, Judge.
Okay, and so outside the agreement, the state was requesting no contact with the complainant. And my understanding, defense, you were opposed to that.
Back then, yes, I was, as I am now.
All right. So state, you're asking for no contact, and I will tell you, the court's concerns was that drugs were being grown in the child's room.
Yes, Your Honor.
All right, and from reading the CPS records, it's the court's understanding that the child does go to school. Is that correct?
Yes, Judge.
Yes.
Yes.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
You can lower your hand, state your name for the.
What?
All right, if you're tested today, what would the result be? And let me just tell you before you answer me. If you're negative, I will remove the no contact order. But if you're going to be positive with an illegal substance, then there's going to be a no contact order because obviously CPS didn't do their work. So if you're drug tested today, what are the results going to be?
I take methadone on a regular basis.
Okay.
That's in my system. I have quit smoking. I knew though it took like 2 months last time for when I was in CPS to get clean. It's been over a month since.
So
haven't
here's the
done
thing,
anything.
see, this is the problem. And this is, I understand that CPS can only keep their cases for a year and they say, oh, people are doing okay, it appears, so we're just gonna dismiss this case. That case has been dismissed for a while. You should not have gone back to using marijuana. And I'm assuming when you say in your system, that's marijuana?
Yes, Your Honor.
All right, and the person, your wife has she been using marijuana as well?
No, no,
Will she be positive?
no, Your Honor.
All right, so here, this is what I want you to understand. Part of my job is to make sure that children are protected, make sure the community are protected when they're placed on probation. All right, methadone. I understand that people use methadone. In my personal opinion, methadone is just another drug, but I understand why it's prescribed, but those levels should be going down. But you should not be testing positive for marijuana. Marijuana is not a part of the methadone recovery system.
Yes, Your Honor.
So why should I allow him to have contact when he's still using marijuana? Or at least live in the home since he's still using marijuana?
Well, I was unaware that he was still using.
Judge, I was as well, with all of my conversations with him, where obviously marijuana was the issue. He did not inform me that several months ago he used it. I can say that what happened in court at the last setting, scared him greatly in terms of having to move out of the house and not being able to be around his children. I've watched the interaction with him, and at least the small one, Layla, is very good. I don't think he will be using it anymore. And of course, I have no problem with the court zero tolerancing him on weekly marijuana urine testing just to make sure that he's complying. I don't think he will. I think he got really scared at the last setting that he needs to get his act together and has not had any since then.
All right, so here's my question for you. Do you have parents in the city?
I have a father, yeah.
All right, is that an appropriate place to stay?
Yes, Your Honor.
All right, so this is what I'm going to order. He's going to live with his father, not live in that home until he's negative for marijuana. You know,
And then as soon as he's negative, he can go back.
when he's negative, they can come back to the court and ask that he be allowed to live in the home. So here's the thing. Your attorney was fighting so hard for you and you didn't do your part. So don't blame her. She did her part. You didn't do your part.
Of course.
Your part was to come into court to be negative, present something to me because you knew the state was asking for no contact. You knew I had concerns because drugs were being grown inside your child's room. You understand?
I do, yeah.
All right. This is what the court is going to do. Are you employed?
I am, Your Honor.
And what do you do?
Packing for Pure Flavor.
All right. There's going to be a $1,500 fine that will be probated. 3 years deferred adjudication. This is run concurrent with 2025 CR 007562C. Is that a motion to revoke?
No, that's the main case, actually, Judge.
Yes, that's the initial drug charge, CTD drug case.
So the 2025 CR 009798, is that the case we're proceeding on?
We're proceeding on both, Your Honor. They're running concurrently.
One of them is a state jail, so if.
Can I have the other case, please? I only have one.
I'm sorry.
All right, the court is calling the 2025 CR 009798 and 2025 CR 007562C. All right, so their end cause number, you know what? Wait a minute, Norma. It's divided up weird. So I have part of this, but I don't have the docket sheet or anything for it. So there's some missing pages. I don't have the, yes. I don't have the admonishments on this. That's the one.
Do you need us to step back, Judge?
Oh, no, just give us a moment.
Judge, can you mic on?
Yes. All right, thank you. Oh, and on this one, do you have a docket sheet?
No.
Thank you. All right. So, and cause number, could you all move? Because y'all are blocking Vashon, and sometimes if you can't see, you can't hear. At least that's how it is for me. So in 2025 CR 009798, there's a $1,500 fine probated, 3 years deferred adjudication. It's a run concurrent with 2025 CR 007562C. There's to be no residing with Layla Aguero. And no unsupervised contact with Layla Aguero until the defendant tests negative.
And Judge, is that negative for the marijuana or do you want them off the methadone as well?
The methadone, that doctors will have to do that. But what I can tell you with methadone, that's not technically supposed to be down. All right. So the levels on that needs to start going down.
Yes, ma'am.
All right. There's to be regular reporting by Zoom or in person, regular random UAs. $100 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. And cause number 2025 CR 007562C, the court will sentence you to 6 years deferred adjudication. There's to be a $2,000 fine. That will be probated. There's to be restitution of $380 to the Bear County Crime Lab for drug testing, 200 hours of community service restitution. I'm going to order the MRT. Once that's completed, 100 hours will be deemed satisfied. And I'm going to order the life skills course. Once that's completed, the remaining 100 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person, regular random UAs, field visits until further notice, 1 time per month. There's to be no residing with Layla Aguero and no unsupervised contact with Layla Aguero until you present with a negative UA. Probation in either of those cases, is there anything else?
Employment, sir.
All right, thank you. Proof of employment, and each cause number, there is to be proof of employment within 30 days, no employment as a home health care provider or with minors.
So Judge, so that I'm fully aware in regards to the methadone, are you saying non-supervised contact until negative from the marijuana and others and anything else other than that methadone, or?
No, it should just be, he shouldn't be positive for anything except methadone. Thank you. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement in that cause number, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Your child is 100% dependent upon you. She can't go in Travis Park and make it on her own. She's 100% dependent on you and your wife. If any of you fall down on the job, then she's just out there alone by herself. You understand?
I do, Your Honor.
So you're gonna have to start doing better, and doing drugs is not good. All right? In this court, communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come to the court. All right, good luck to you.
Thank you, Judge.
Thank
May we be
you.
excused?
Yes.
Judge, may I approach?
Have they,
No, not yet, Judge. I'll get you a line in just a few minutes.
Oh, okay, I didn't know.
oh yeah, just call up. Mr. Cox, is your client going to be positive?
You'll be negative, Judge.
Okay.
Yeah.
All right, could you give me Mr. Cox client?
Mr. Cox is your client,
It's a Garrow, Kelly, and they should have, that should be 2 cases as well.
Oh.
Hi. So you drug tested today. Are the results going to be okay?
Yes, ma'am.
All right, I'm gonna have you drug tested today, all right?
You have a seat, Mr. Seeloff. I'm writing you in already. You'll be next.
Here's Kelly.
Court is calling 2025.
Just a second, Judge.
Oh, I'm sorry.
My microphone cut off on me. Cord up there.
Thank you, Mr. White.
Try. Here you go, ma'am. I got it. You're welcome. We're gonna knock anything else over and destroy it. Over the road. Got it?
Okay.
Oh, it's all like 12.
Your Honor, with that, situation with drug, she's on prescription.
Methadone as well?
No.
Okay. And what are the prescriptions for?
For mental health.
Okay. Just
right.
as long as it's not an illegal substance.
I just don't know if they come on our drug test or not.
Oh, we'll find out. All right, Mr. Cox. I don't have the trial court certification on the 16 cause number. The cause number ending in 16. So if you could,
Should have been both our.
if you could grab that for me. All right. Do you need a pen? And to everyone else, be patient, put some patience in your pocket. We're gonna go as quickly as we can, but maintaining everybody's humanity, because these are not numbers, these are people. And it takes time so that I can make sure that I set conditions so you can be successful. All right, the court is calling 2025 CR 007562B and 2025 CR 009816, State versus Kelly Aguirre. Can I have parties announced?
Rick Pena for the state of Texas.
Cornelius Cox for the defendant.
All right, and are you Miss Aguirre?
Yes, ma'am.
Thank you for dressing appropriately for court. All right, we're here for sentencing. And the reason why your attorney wanted this recalled and not do it on the day that was originally set is because of no contact orders, right?
Yes.
And it's no contact orders regarding your child. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kelly Owens.
All right. So, if you're drug tested today, what will the results be?
Clean. Negative.
All right. And you mentioned earlier about mental health. Are you seeing a doctor?
I currently got enrolled with the Center for Healthcare. My first appointment is not until October, but I have been going to the medical transplant specialty in the medical center for taking medication and stay on top of it.
Okay. And let me just tell you, the reason why I asked that of you is because I want to make sure that you're receiving the help you need to be successful on this probation.
Yes.
All right. So were you aware that your husband had been using?
No.
So you need to make a decision on who you want your star to be attached to, because I'll tell you what I told him. Your child cannot take care of herself. She can't survive at Travis Park. She's 100% dependent on you as her parent and your husband as her parent to do what's in her best interest. And what's in her best interest is not continuing to use illegal substances. Do you understand? All right. And cause number 2025 CR 009816. The court will sentence you to 2 years deferred adjudication. This will run concurrent with 2025 CR 007562B. There's a $1,500 fine that will be probated. Are you employed?
No,
All right. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. MIC evaluation out of custody. Continued referral to Center for Healthcare Services. Regular reporting by Zoom or in person. Regular random UAs. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. State, are you still requesting no contact with the child?
For her, we are fine with no harmful injurious contact so long as there are regular field visits by probation throughout the duration of probation.
All right, there's to be no harmful or injurious contact with Layla Aguirre. Your attorney will explain to you what no harmful or injurious contact means. There's going to be field visits until further notice. And so you know, Jacob Aguirre is not allowed to reside in that household until the court allows him to reside in that household. And whether or not he resides in that household is 100% dependent upon his actions. So if he continues to use marijuana, that's on him. You understand?
Yes.
But if you allow him to reside in that household, that's going to be a violation of your probation. You understand? Okay. So no residing with Jacob Aguirre. Now that can change once he's negative. Do you understand? Probation, is there anything else with regards to that case? All right. Did you review the trial court certification of defendant's rights to appeal in that case? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're proceeding in 2025 CR 007562B. The court will sentence you to 6 years deferred adjudication. There's a $2,000 fine that will be probated. This will run concurrent with 2025 CR 009816. I'm not going to order restitution for the drug testing because he should be paying for that. And he's already supposed to pay for that. I think it would be double dipping if each party paid the amount for testing of the same drug. So there's going to be 200 hours in community service restitution. I'm going to order the MRT. Once that's completed, 100 hours will be waived. The other 100 hours will be waived once you complete the life skills course. Proof of employment within 30 days, no employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. No harmful or injurious contact with Layla Aguirre. Field visits until further notice, 1 time per month. No residing with Jacob Aguirre. And again, that will change once he tests negative. Probation, is there anything else? Okay. Is there anything else you need from the court?
Mm-hmm.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. You went through CPS and you went through CPS. Usually those cases take a minimum of a year. You went through that and you got to start making decisions whether or not you're going to hang your star with your husband or not. But if he continues on this path, things are not going to go well. And when things don't go well for him, if you tied to him, they're not going to go well for you because Child Protective Services will be involved back in your life. And all of these Child Protective Services cases, that is permanently on your record like a criminal history. Whenever you pick up a new Child Protective Services case, a history will come up of all your cases with them and whether there were reasons to believe or not. And guess what? If your parents had a Child Protective Services case when you were a child, that's going to come up as well. So you better start making changes. You understand? All right. Good luck to you.
Thank you.
Ms. Ready?
You ready for the next one, Judge?
Yes.
Page 5, 4 down, it's, Brandon Rodriguez.
All right. Thank you. Brandon Ramirez.
Morning, Judge.
Good morning. How's it going?
Not bad yourself.
Oh, I'm doing great. I guess you didn't realize you were coming in to work with our equipment.
Just trying to be helpful, Judge.
You're trying to be helpful because, you see Cornelius is there. He said he's having dreams about Florida winning the championship.
I definitely have to humble myself to Mr. Cox. There's no ifs, ands, or buts about that. Various reasons.
And then he has dreams about Texas A&M.
There you go. One day.
We all have dreams, Judge. I dream about the Razorbacks too. There you go. So we all have.
What's
dreams.
that song? I have dreams.
Oh, yeah.
All
Good
right.
for you.
So, where are
He's
we on this
already
thing?
giving me a. He's already beat me up. I can't hold myself. Wow.
So where are we on discovery?
I believe the discovery has been presented, Judge,
Mhm.
and I think currently I talked to Mr. Marshall about, is about, contacting the victim.
Okay.
And on certain aspects of a plea offer.
All right, Ms. Ferguson, if I can have a 30-day reset.
September 25th.
All right, we'll be back on September 25th. In states, you need to be prepared to tender an offer at that time. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you. Yes,
Thank
sir.
you.
Thank you.
You're welcome.
So you come to the Austin game? Yeah. That's gonna be a great game.
Mr. White.
Yes. Okay, yeah. That's gonna be a great one. I was up there.